Hello, I'm Eleanor Solomon. I'm a solicitor in the housing department at Anthony Gold, and today I'm going to be talking through some of the legal issues that can occur for the residents of a block of flats or estate when it's redeveloped, when there's some kind of major works done to it. This is obviously something that happens at all times, but especially now more than ever, there is a great deal of redevelopment going on despite the difficult economic situation. As most people will know, following Grenfell, a huge number of blocks were found to have cladding that was flammable and not compliant with building regulations, and that needs to be replaced. And it's quite common that when this cladding is taken down, other works are done at the same time, or issues are revealed that had been covered up by the cladding. So it's not uncommon for these works to be happening and works to be taking a lot longer than they were originally planned for before the cladding was taken off and the issues underneath were revealed. So as of the 31st of May 2020, there were 300 developments with ACM cladding that needed to be removed following Grenfell, and there's other types of cladding that needs to be removed as well, not counted here, and works have only started on those, of 140 of those so far. Some are ongoing, some are complete. So this is a big issue that's affecting a lot of people at the moment. Despite the difficult economic conditions we're in, there are lots of major works going on. So today I'm just going to talk through some questions that have been asked to me by residents in this situation, and hopefully if you're in a similar situation it may answer some of your questions too. So the first question I was asked was, what obligations do landlords have to maintain rented accommodation, and do these responsibilities change because they're intended to demolish and redevelop the property? Or demolish in some cases, redevelop in others. So it depends what your status is, whether you're a leaseholder, including a shared ownership leaseholder, a tenant, or a licensee, so a lodger. So landlords are obliged to tenants who have tenancies of a term of less than 7 years, so that will be secure tenants, assured tenants, and assured short-hold tenants, to repair the structure and exterior of the building, so that's the roofs, the external walls, the windows, and the services for gas, heating, electricity, and sanitation, including water. So that covers a great deal of things that can go wrong with a property, but not everything that could possibly go wrong. So for example, a kitchen that's outdated and not damaged by something else wouldn't come under this. And they're also obliged to keep a property fit for human habitation, which covers a really, really wide range of issues such as pest infestations, excessive heat and cold, and is more based on the effect that living in a property has on you rather than the other legislation for disrepair, which more focuses on the type or part of the building that's in disrepair. So a landlord has obligations to tenants under the tenancy agreement. They can sue them if they don't keep to those obligations. How does this relate to the current situation? I mean, many properties that are having major works done to them have been in disrepair for a long time, and that's why they need the major works. Equally, to do building works, you have to break things. If you're replacing the windows, you have to take out the old windows, and then for a period you have no windows or insufficient windows. Same with the cladding, you have to take the cladding off. If you put new windows or new cladding back on straight away, then there's no breach of the landlord's repairing obligations because they've fixed the damage they've done within a reasonable period of time. However, if your landlord takes out your windows, takes off your cladding, and then something goes wrong and you're just left like that for an extended period of time, which doesn't seem to me to be particularly uncommon, then the tenants will have a claim against the landlord in disrepair as well as in other legal causes of action. Does the landlord's responsibilities to repair things change based on the fact that they're going to demolish or redevelop the building? The age and character of the building will be taken into consideration, and ultimately it's up to the landlord to decide what works they do to put a property in repair as long as the property is in repair at the end of it. So for example, if a landlord has major works scheduled to replace all the windows in a block of flats and you complain that your window's leaking or your window's broken, your landlord has no obligation to replace your window alone a year before they replace everybody else's, but they do have to do some intermediate works just to make sure that your window is no longer leaking, broken, it's functioning basically as a window, can open and close, etc. So yes, these major works may have some sort of bearing on what's done to the property, but it doesn't mean that your landlord isn't responsible for keeping your property in repair. They are responsible for that before and during major works. And in addition, environmental health departments can still serve notices on landlords if the property is in a poor and dangerous state. If you're a leaseholder as opposed to a tenant, then your landlord has to keep your property in repair in accordance with whatever it says in the lease, and this will just massively change from lease to lease. And what happens if you are a subtenant? So your landlord is not the owner of the block, your landlord is a leaseholder, and you are privately letting a flat from your landlord. Well, your landlord will have obligations to you to keep the property in repair, despite the fact that they may not have massive control over it. And you may have a claim against the owner of the block in what's called the law of nuisance if, for example, the owner of the block or the freeholder is causing leaks to come into your flat or causing undue disruption. And I'll talk a little bit more about that in answer to the next question, which is, can tenants and leaseholders claim for the disruption caused by building works? So the short answer is yes, sometimes. A landlord has a duty to minimise the interference caused by refurbishment works and should take all reasonable precautions to avoid disturbing the residents. So living in a building site during works is always going to be unpleasant. There's always going to be noise, there's going to be dust, there may be scaffolding up. It's not going to be very fun or pleasant, and it is going to disturb you. And in many cases, it's not possible to carry out works without some disturbance. However, there are behaviours or timescales that go beyond a normal or reasonable amount of disturbance and basically demonstrate that the landlord has made no efforts to minimise the disturbance to the residents. So some examples of this, which will massively depend on a fact by case basis, are mismanaging the work so they go on too long. So for example, you always will have had to put up with a period of noise, having your car blocked off in the car park, having scaffolding up, that's inevitable. However, after a certain period of time, if the works are mismanaged so that this just goes on for years and years and years, in many cases, then that's an unreasonable disturbance, and all the kind of nuisance from the building work, which would otherwise be normal, becomes unreasonable and actionable. And then there are just little things that you can do on site to make things more pleasant for the residents, which are often not done. So failing to dampen down surfaces so that excessive dust comes into flats, leaving residents without light for excessive period due to dark covered scaffolding when it doesn't necessarily need to be used, and other lighter scaffolding cover could have been used. Making noise before 8:30 or at night, not allowing access to open spaces for excessive periods when access could have been allowed, like in playgrounds or communal balconies, leaving rubbish, tools and dangerous materials around, and allowing leaks into properties are all just some examples. Cutting off services as well for electricity and so forth. So if the freeholder or the person doing the development is doing this kind of thing, then you may have a claim against them for money and also for an injunction to stop them doing it. So what happens if work started and everything was going to timetable and then they stopped due to coronavirus restrictions? Would you have a claim for delay in that situation? The restrictions and laws never stopped works continuing inside homes, but nonetheless, obviously, if works did stop around March to May 2020, it's pretty hard to argue that that wasn't reasonable. And there were delays in setting up a new system of health and safety for workers was difficult, sourcing materials was difficult, getting people to come to work was difficult. I don't think a court would be very sympathetic if the delay was caused and could be proved to have been caused purely by coronavirus. That said, if tools were downed, the building shouldn't have been left in a hazardous state. And on the 11th of May 2020, the Department of Communities and Local Government wrote to social tenants saying that work should be continuing. So some delays are inevitable. It can't be, the coronavirus situation can't be blamed for everything. What happens if my landlord wants me to permanently move out so they can redevelop the property? That just entirely depends what kind of tenancy you have. If you're a private tenant or an assured short hold tenant, then if the circumstances are met, your landlord can just probably bring a Section 21 proceedings against you, and they probably can make you leave. Secure or assured tenants, landlords can bring possession claims against them to force them to leave the properties, and the judge may give the landlord possession if suitable alternative accommodation is available or will be at the time the possession order is made. And then, what right do I have for a landlord to find me a suitable like-for-like home within the area on a temporary basis? Unfortunately, there's no direct legal right for a landlord to provide temporary accommodation to any particular standard, or indeed at all. Before possession proceedings have started, there's no requirement to give any reasons to turn down accommodation. But if possession proceedings are started against you, you may have to accept accommodation that the court considers to be suitable, but this would be permanent rather than temporary. And what would be suitable will depend on your particular situation. So it might be unsuitable if you'd be overcrowded there and you're not overcrowded in your current accommodation. It's so far away from your children's school or work that you couldn't reasonably get there every day, or you had a support network in your area for medical reasons, or childcare from your family which allows you to work, and this would be taken away from you by your move, or if you were disabled and the new property was inaccessible. I've been asked if I've been asked to go on the council housing list to be rehoused, does this devolve my landlord of any responsibility to rehouse me if the block's being permanently demolished? And the answer to that is no. Being on the council waiting list doesn't affect whether your landlord should rehouse you if they're permanently demolishing your property. I've been asked if the maintenance of a building falls to a very poor standard and I feel forced to move out, would this mean I would make myself intentionally homeless, in the context of making a future application for homelessness to the local authority? It will depend on a case-by-case basis. It is likely that you would be found to be intentionally homeless in this situation, although possibly not if your health was affected by the conditions of the property and the conditions were very poor. But moving out without having anywhere to move to is not a good idea, and you should take individual legal advice first if you're thinking about this. How can I pay for a claim against my landlord, or to defend a claim against my landlord? So if your landlord's bringing possession proceedings against you, legal aid is available. Legal aid is not available in most housing disrepair claims. It's not available to get compensation. Here at Anthony Gold, we would offer a conditional fee agreement or no-win, no-fee agreement in appropriate cases of disrepair or disruption caused by undue building works to get compensation, and also injunctions for works to be completed. So this basically means that we will act for people with good claims without charge as the case is going along. And the reason that we could do that is because if you win, your landlord will have to pay your legal costs. How much could you get from this kind of case? As I previously mentioned, the first thing that you would get, if necessary, is an injunction, so an order forcing your landlord to do specific works by a specific deadline. You'd also get compensation. The compensation is calculated as a proportion of your rent for the time that you've lived in the property whilst it's been in the state of disrepair or disruption. And if you're a leaseholder, it's calculated as a percentage of the market rent were you to let your property out on a private basis if it was in good repair. And you're also compensated for the additional expenses you've gone through, such as energy bills and lost items. It's very much a situation where you'd need individual legal advice on the value of your claim, and it would depend on the individual circumstances and how badly you've been affected. If you do have any more questions, if you're in a block of flats or an estate which is being redeveloped and you feel that your landlord either has kept the property out of repair for an unreasonable period of time, or they've caused unnecessary disruption to you, then do get in touch with Anthony Gold and we'll advise further.